A private copying levy is a government-mandated scheme in which a special tax or levy is charged on purchases of recordable media. Such taxes are in place in various countries and the income is typically allocated to the developers of content. Levy system may operate in principle as a system of collectivization, partially replacing a property approach of sale of individual units. History. Such levies were first introduced in Germany in the 1960s. With the advent of the audio cassette, legislators were persuaded that cassette recorders would decimate sales of records as friend after friend would then make copies of only one purchased album. Levies today are assessed on recordable compact discs, a form of media that did not exist when levies were first conceived. Although the bulk of unrecorded compact discs are actually used in the computing industry, they are still taxed to provide a revenue stream to the recording industry. Levies are often considered a compensation for illegal file sharing. This is debatable, however. Levies could be seen as not being an advance for fines, but rather, only intended to compensate for copies in the private sphere that are legally allowed in many jurisdictions. A notable exception in Europe is the UK, that does not allow private copies. But generally legislators allow private copies for two reasons. Firstly, because otherwise the enforcement would be unfeasible for private reasons. And secondly because the administrative burden would be disproportional. European Union Review. On 9 July 2015, the European Parliament approved a non-binding resolution asking a review of the levy in the European Union, building on previous resolutions and studies. 57. Recalls the importance of the private copying exception that may not be technically limited, coupled with fair compensation of creators, invites the Commission to analyze, on the basis of scientific evidence, Parliament's resolution of 27 February 2014 on private copying levies and the results of the latest mediation process conducted by the Commission, the viability of existing measures for the fair compensation of rights holders in respect of reproductions made by natural persons for private use, in particular in regard to transparency measures. 58. Notes that private copying levies should be governed in such a way as to inform citizens of the actual amount of the levy, its purpose and how it is going to be used. European Parliament Resolution of 9 July 2015 on the implementation of Directive 2001/29 EC of the European Parliament and of the Council of 22 May 2001 on the harmonization of certain aspects of copyright and our related rights in the information society. Questions on fairness. A difficulty that immediately arises is the practical impossibility of devising a mechanism for distributing the proceeds to copyright holders that is considered fair by all copyright holders and consumers. Implemented systems are typically restricted to music and may distribute the proceeds proportionally to a measurement of sales of CDs in music shops, or amount of airplay on radio or the like. This ignores other distribution channels such as the Internet, and it disproportionately benefits popular artists and publishers of the related products. Fairer methods would arguably involve extensive sampling of purchases to determine actual recording behavior, or alternatively paying all musicians at a simple flat rate. While the prime purpose of levy systems is to compensate authors, some part of the collected money is also used for general cultural funding purposes. In Germany this is even required by law. It acknowledges the purpose of cultural diversity, which is not necessarily identical to free market effects. This funding is usually executed by the same entities that distribute the levy money to individual authors. One may question, however, whether these entities are properly qualified to make culture policy. Levy systems assume that all authors want to exploit their work for money. However, this is not always true, especially on the Internet. Many authors do not write to entertain, but to inform readers, listeners and viewers. Often the purpose is to reach the widest possible audience rather than make the maximum profit from the copyrighted work by itself. The discrepancy between reality and the assumption underlying a levy system is growing as Web 2.0 matures, with pervasive user-supplied content, from Wikipedia to YouTube. A further problem is to find a proper tariff base for levies. Conceivably, the levy may be a percentage of storage media sales price. The implication of such a scheme is, however, that the author gets ever less as technology proceeds and becomes less expensive. But a price based on units of information is not fair either, as for instance a DVD can be used to store a film, a computer game, a large amount of documents, or measurement data. The cost of producing a certain amount of bits widely varies by type of information. Measurement data is even not copyrighted at all. Yet in today's world of converging technology, storage media can be used for a wide range of purposes. An implementation question that arises is whether the tax applies to any type of copyrighted work or is restricted to a limited field such as music. If it is restricted, then the issue arises of how to collect the tax on media, which can also be used for other purposes. The options include collecting the tax on all media, regardless of the end use, and ignoring the injustice to purchases with non-covered uses, allowing taxed and untaxed media to be sold, but with only the taxed media providing the copyright relaxation benefits. Collecting the tax on all media but allowing purchasers to claim a refund for media applied to non-covered uses. Contrary fairness arguments. Although these complexities make the systems of levies are far from perfect, they do have some advantages related to fairness in that since there is compensation for private copying, whereas in countries where there is no levies, there is a substantial amount of copying taking place without any due compensation being made. With respect to fairness in countries with the levy, everyone shares in the financial burden caused by the levy. In countries that do not have the levy, many people are copying music and never receive any reprimands, while others are made an example and prosecuted. This is the similar argument that non-proponents to the levy system use to show fault. They advocate that if the levy cannot be precisely applied to the people that are private copying, it is a faulty system. Likewise, if one cannot reprimand all people that are copying illegally and not compensating the music industry, this is also a faulty system. One system oversubscribes, the other undersubscribes. Both have faults. Finally, those countries that do not have private copying laws are in fact making many of their citizens criminals. A law which makes potentially more than 50% of the population criminals does not seem to be a fair business practice. Lawyers rather than artists may well be the greatest beneficiaries in non-private copying countries. This argument assumes that private copying can only be allowed with a levy. Legal effects. It is theorized that such a levy may be linked to a corresponding relaxation of copyright law, by permitting the recording of copyrighted works on media for which the tax has been paid. However, there is little evidence to support this theory. On the contrary, lobbyists representing publishers and copyright holders have increased pressures to implement more restrictive laws, even on countries that have implemented private copying levy. In 2007, it was reported that International Intellectual Property Alliance put 23 of the world's 30 most populous countries into priority watch list, even though the United States, which was not in the list, has laws that are more liberal than the laws from the countries within the list, even when restricting levy system to devices that primarily play music. This itself creates loopholes that prevents collecting levies from cell phones, PDAs, and other all-in-one portable electronic devices. As a result, copyright holders will have to rely on even more laws to collect levy, and to increase rates of already levied products to recover perceived losses, which run against the political trends toward eliminating levy systems.